Hi, I am Josh Freeman. I am a business attorney at Freeman Level, and I'm excited that you're taking the time to watch this video today. Freeman Level is a law firm where we help entrepreneurs and small business owners to understand and take the right legal risks. And as part of our goal and mission to do this, we've prepared this presentation from idea to exit to help teach the legal principles about how businesses should be structured, how they can scale, and how you can sell your business. So today we're going to continue on and talking through the structuring phase of your business to make sure you have a strong and solid foundation on which you can grow and ultimately have a business that someone's going to buy from you. And so today we're going to be talking about buy-sell provisions. We've been talking a little bit about this concept of controlling your cap table, and we've recently done a deep dive into equity splits and vesting and how that kind of works. Now we're going to do a little deeper dive explanation on buy-sell provisions. These are things that a lot of business owners hear but aren't entirely clear on what they mean. And so that's what we'll get into. Basically, the basics of a buy sell provision are for protecting a business from these types of events occurring with an owner. So one of the primary things that it focuses on is protecting the cap table against the death of an owner. So one thing that's important for businesses is to be able to control who owns their business, who has voting rights, and how all that works. And so when someone dies, that person, obviously is no longer there to make decisions, be involved, and those kinds of things. And so then, an estate or a trust or someone then gets put in control of that person's ownership. And then all of a sudden you have different people making decisions and influencing the business. So a lot of businesses like to protect against that by having, a right, but not an obligation to buy back the equity at fair market value from an owner when they pass away. And so that's one of the key parts that a buy sell provision provides for. So how it kind of works mechanically is an owner passes away, the company has a period of time in which they can say, yes, we'd like to buy that equity back, and then they go through the process of valuing what that equity is worth. And then once they have the value, they then pay that value or a portion of that value, and then the rest of it over time to that owner. So that's kind of the basics of how that first piece works. Then another thing that it likes to protect against is disability. But before I go there, let me take a step back and kind of a lot of the reasoning why companies want to have the rights to buy back equity in these different circumstances is to control who votes, but also a lot of times owners provide a very important role in the business. And so if a key employee that has significant equity ownership passes away, it's important to be able to, take that equity back, free up that space on the cap table so that you can grant more equity to a replacement CEO or a replacement CFO or whatever it may be. And so we try to do it in a way where it fairly treats the family of, the deceased or disabled, but also allows the company to have the equity it needs to make the grants and to do those things to continue to grow and continue to properly incentivize the key people in their business. So that's what that's kind of about. So moving on to disability, similar to death, typically what these provisions provide for is if an owner has a long-term disability that they can no longer participate and be involved in the business, then they're able to then the business is able to make that election to buy it back. It typically requires at least a physician, if not multiple physicians, opinions that the person is in fact disabled, and those kinds of things. The mechanics are similar to what we described with death. With regards to divorce, this is a little bit different, because the protection here is to ensure that if a partner gets divorced, and because divorce courts have a lot of latitude to make orders that can be binding on a business when, one owner owns some equity, this is to make sure that the company is in a position so you don't have like two former spouses on the cap table fighting it out and having issues there. And so, so with this, basically how it works is, if an owner gets divorced and their ex-spouse receives an award of that equity from the court, then that triggers the company's right to essentially pay and buy that equity from the ex-spouse based on the terms, whether it's all cash up front or over a period of time on a loan. So that's what that's about. Some buy-sell provisions even give the owner spouse the ability to buy that from their ex-spouse before the company. But most of the time it's just the company having that right, and then the company can work out with its former owner if they want to sell that back to them or what they want to do that way. So that's kind of how the divorce side works. And then the other protection is for situations mostly comes up with bankruptcy. So when an individual files for bankruptcy, if an owner files for bankruptcy, at that point in time, that owner loses control of the assets that they own, and those assets essentially become under control of the bankruptcy trustee. And so there are some caveats to this, but in general, when there's a bankruptcy, the bankruptcy trustee then, has a major say in the assets and how they're, voted or how they're, distributed, and the bankruptcy court gets involved in all of that. And so a lot of businesses don't want to have a bankruptcy court or a bankruptcy trustee getting in their business and, and those things. And so again, you provide this provision so that the business has the ability to buy back that equity from the bankruptcy court or the bankruptcy trustee, or however that plays out, so that the company can move on, continue to do its business, and not have to deal with the inefficiencies and the problems of dealing with that kind of ownership. So those are kind of the basics of a buy-sell agreement. And we feel like these are very important to have, and it's we put them in as optional provisions so that the company, if something happens, someone passes away and it goes to that person's spouse, if that spouse is on good terms and the company wants to keep them as an owner, they can do that, and you can be flexible, but being able to be in the driver's seat and be able to purchase back equity is a really important thing for a business. Last note I want to have is to beware the shotgun provisions. I've seen some clients come ask about these provisions where essentially it's a provision where one owner says to the company, I'm willing to either, well, it's not to the company, to another owner, say, I'm either willing to sell my equity at this price or buy your equity at this price. And then the other owner has the ability to say, okay, I will sell or I will buy. And the problems with this provision is, one problem is if there's more than two owners, then it gets very, very complex and complicated, and you can have multiple competing offers and different things that way. And so it can be, rather problematic. It can work with two partners, but the problem is it can be easily and regularly abused, especially if one partner ends up in a situation where they have significantly more buying power or financial ability to control those situations. And so, so if one party knows that the other party doesn't have the money to, purchase their equity at a certain value, but they see a huge opportunity in the business and it makes sense to make that play, it allows for, some unfair type of negotiations and forcing people out of businesses. So, so just be careful with those provisions. Those sometimes come up and, can be recommended. But, we've seen a lot of problems with those. And so, unless they're very well thought through and very well understood by the owners of the business, it's typically something to be avoided. But yes, so those are kind of the basics of the buy sell. So typically, yeah, it's the 3Ds that it's focusing on: the death, divorce, disability, and then bankruptcy and other court orders that change ownership automatically that are trying to be protected against. And so I hope that this has been helpful and understanding a little more about buy-sell provisions and why they're important. And these provisions can be integrated into an operating agreement, a shareholder agreement. They can come in this separate buy-sell agreement. So there's different ways that they can be built into a business. But yes, thank you for taking the time to listen. Again, my name is Josh Freeman. I'm a business attorney at Freeman Level. And if you have any questions or want more information, you can reach out to me at the email address on the screen, or you can find me on our website. But again, yes, thank you for your time, and good luck.